providers from discriminating against them going forward. Now, what is a housing provider? You may, as an association, not think of yourself as a housing provider. You may say, I don't, we don't build houses, we don't rent them, we just make some rules about houses. The statute covers you. So you are a housing provider. You are covered by the Fair Housing Act, and you're covered by the Oregon equivalent of the Fair Housing Act.
What is this? We have a
So,
poll.
what are the protected classes? The federal protected classes are here listed. So, race, sex, national origin, religion, or familial status. So we kind of need to break that down a little bit, I think. Race, I think that should be pretty obvious. Sex, whether you're male or female. National origin, where
I
you were
think
born.
sex encompasses more than male or
Even if
female
you
now,
don't look like you're
lawyers.
from another country.
Well, I'm not kidding.
If you're
Non-binary.
discriminating based on someone being from a foreign country, religion. Familial status is probably the one that is the least obvious what it means, but basically it means having kids and being married or being an unmarried mother with kids. Those are protected classes. So if you want to discriminate against those, I'm sorry to inform you that you can't do that under federal law. You also can't discriminate based on someone because they have a disability. Now, the statute, Chris calls that a handicap, if I'm not mistaken. We don't use that term anymore because it's, I guess we view it as disparaging, but that's what the statute says. We'll call it disability. But if you have somebody that has some sort of disability, then they're also protected by it. And I think actually a lot of the time people get really tripped up on that because they feel like, I'm not discriminating against someone because they have a disability. I'm just treating them like everyone else. And the Fair Housing Act doesn't say that you treat people with disabilities like everyone else. It requires you to treat them different and to accommodate them. And that's really hard for board members to get their heads around. They really want to just say, the rules are the rules. I apply them equally to everyone. And you're being treated the same as everyone else. But the law requires you to treat people with disabilities a little better than everyone else. If you can do it, and if what they're requesting is reasonable. So.
No, here comes Jeremy.
Ryan, if
What
I
we got
may,
going now?
we skipped a slide on the dual sovereigns, but the reason behind that slide was to point out that these issues come up both at a federal law level, which is the one that typically is used most often, but Oregon and Washington both, for those of you that may live in Washington, they both have fair housing laws of their own, and they're largely similar, but they're not the same. So the categories that we are showing you here right now are the categories at the federal level. Oregon has a little more broad.
Yeah, what are those categories? They're sexual orientation.
Yeah, source of income.
Source of income. So source of income is a little confusing to people sometimes, I think, but I think we generally understand that as you can't discriminate against someone because they're on disability or on Social Security. Those are the obvious ones.
Or rental, or not rental, but like Section 7 housing vouchers, things like that. That's what source of income means. It has nothing to do about whether they got their income gambling in Vegas, or they work as a lawyer, or they have a side hustle selling Costco products on Amazon.
Yeah, I mean I don't think that was the intent, but of course it just says source of income. So I suppose somebody has an argument there.
Yeah,
I agree with you.
What people make, but the legislature is pretty clear on it. I've had to argue it before.
Okay.
So keep in mind that there's a difference. All right, Ryan, why don't you talk about this quid pro quo and hostile environment issue? Because I got a question earlier on the chat in the Q&A that was asking, well, we've got owner-to-owner disputes. Really, can we just send them to mediation or let them handle it? Another question was, about harassment from an owner and how that works. Is there anything the HOA can do? And in most cases, the answer is no, it's an owner-to-owner dispute. But this is one area that they need to be aware of. So
I
why
was
don't you
telling
chat about
Kathleen,
it?
that's the PS I had
Yeah,
last
a
night.
couple of years ago, it doesn't seem like it was that long ago, Chris, but I was looking it up and I think it was 2016. So we've
Because
been
that
under
is
this now for
outrageous.
4 years. Or
That they would spend a
6
month
years. Let me do my
creating
math
that
again.
form.
6
No
years.
wonder your golf scores
Make
are
it
always
fair
high.
and legal.
That is why.
Now I
There's
see.
no
Yeah.
in-person
So
meeting.
we've had this for we've
Because
been
they
living with
can't
this for a
sell
while
out,
now.
said out loud
Right.
But
to
What's
anybody.
that? Right, say that again?
the Department of Housing and Urban
why we're not voting in the
federal
in-person
agency
meetings.
that administers
Manipulating
Yep.
the Fair Housing Act
favor.
made
Yep.
some rules
Well,
about what it can
So that nobody can say anything in the- before the vote.
And the board members will
And
allow it.
they
But they
made-
spent all that
here
time
you
her
can see
forcing
the
them to
citation
come up
to
with
the
a fair and
rules,
legal
24
ballot, make sure it's
CFR.
legal.
Those are
It
the
got approved,
those,
and
that's
what's the
the
first thing
Federal
she did?
Register
Goes
where
against it. Didn't use the
the
ballot.
government agencies write down their rules.
Yeah.
And
Didn't use the ballot.
So they made 2 rules. One is prohibited quid pro
This is
quo,
why-
Uh-oh, smells like cheddar
Harassment.
bacon biscuits.
and one that prohibited hostile environment.
Rob's gonna be sorry.
Now the quid pro quo one I
Use
think
this
wasn't that shocking, but the
whenever you
hostile
talk to
environment
Jason,
one I think was pretty shocking,
because
or at
he's
least
actually admitted
gave us some pause at the
Shane
time.
is a great tool.
So quid pro
Right.
quo, that's Latin,
Right,
It's gonna hurt him.
right.
He's allowed.
means this for that. And basically what this
Okay. Thanks,
long
honey.
paragraph here is saying is,
Number one.
you as a housing provider cannot say, oh, I will give you a certain privilege or I'll
I
do a
don't know, I've
certain
never-
favor
oh.
for you if you do something
Bob,
for
look
me.
at what we did.
So-
Look what you didn't get, buddy.
The obvious one would be some sort of sexual favor, a sexual transaction, I'll let you pay your association dues late if you do some sort of sexual favor for me. That's gonna
That
be a
sounds good to
violation
me.
of the
Come on, Rachel.
regulation. I think that's pretty obviously wrong, right? The one that Chris was hinting at earlier was the hostile environment harassment. And basically what they said, the Fed said here was,
I'm not paying attention.
if
I think it's hard to see through the windows.
if there are
here.
people in your association, not necessarily board members or anyone that the association controls, but there are other owners in the association that are creating a
Bob.
hostile
What
environment
you missed out on.
based on a protected class.
I'm sorry I didn't
And
have it here for you guys.
The board has the
No,
power
I'm
to
not saying
intervene
don't
and
obey
stop
everything.
it.
Everything Paul was here.
It has to use that power and
Paul
intervene and
likes
stop it. Otherwise,
What's it
it
called?
is
This is Dodo
discriminating
Bakery.
Oh, it is.
based on allowing a hostile environment. And so the provision that most often comes into play here is your nuisance provision in your documents. Most of you don't have a provision in your
There you
documents
go.
that say don't
I cannot
discriminate.
enjoy my
Owners
services
cannot
or
discriminate against
facilities
somebody else based
Well,
on being in a protected
based on
class.
harassment,
But
environmental
most of you
harassment.
do have a provision that says there will be no nuisances, there are offensive behavior.
That's not
Sometimes
good.
you'll even have one that says, the provision will even say no unlawful behavior.
Are you leaving us?
And HUD's position on this is that you, as the board, need to step in and stop that kind of harassment from happening.
Well, the board's causing the run now.
So I don't know, Chris, what kind of experiences you've had with this, but I've had experiences where an owner will come to the board and they'll say, my neighbor is harassing me and it's because I'm Muslim. And then Chris, what do you advise the board to do in that kind of situation?
Well, I think the board has a duty to investigate. One of my first ones actually in dealing with this was related to 2 different owners who were fighting back and forth using different special classes. So one was religious or nationality based, Muslim in fact, and the other was national origin and ethnicity. If I remember correctly, it was Hispanic, and they were arguing that each other
Non-binary
was
is not included
discriminating
yet.
against the
So
other
you think you're gonna
on
take
the
a literally
basis
act of
of
Congress?
their protected class. And we had to sort through it, and it was very difficult. I'm not going to lie. I mean, that's just a hard thing to do. We also see it in terms of 2 disabilities butting up against each other, and someone arguing one way and someone the other way. And frankly, there's no easy, bright line answer I can give anybody. That's a fact-centric issue that we have to wade into. But I think under the rules and the way the DOJ is interpreting this now, when it comes up, the board at least has an initial duty to investigate it and look at it and see what kind of merit there is to it.
Yeah, I think that's kind of how the board protects itself in these situations. And even, I think one thing that I see happen from time to time is
I wonder who this Linda Brown is. She keeps
the
asking
board will
questions.
get a complaint, and it'll be from someone they've had problems with in the past. And they'll think to themselves, this person's not credible. I don't take this complaint seriously because this person's a problem, and I don't want to waste my time looking into it. But the way you protect yourself when you're in association is you take it seriously and you look into it. And then I think a lot of the time, sometimes the outcome is less important than the due diligence you do. If you do your due diligence and you say, well, we looked into it and we couldn't find anything to it, so we didn't take any further action, I think you've protected yourself. But if you ignore it, then I think you've exposed yourself. So, do you have anything else to say on this one?
No, let's boogie.
Okay.
Let's talk briefly about reasonable accommodation and reasonable modification. Part of our subject today is the complaint process, so I want to leave adequate time for the complaint process. But a war story I want to tell
Is it your
about
answer
this
to your
deals
question?
with reasonable accommodations and modifications. This slide relates solely to the protected class of persons with disabilities, and so when we're talking about race, religion,
yeah.
sex,
Unfortunately.
familial status, all that, this does not apply. Again, this is just disabilities. An accommodation is a change in policy, procedure, rules, practices, services offered that includes declaration covenants or bylaw restrictions. It's not just board resolutions or less formal things. It can be something that's recorded, and you give an accommodation or a variance. I like to use the word variance from the requirement that's there. A modification, on the other hand, is an actual physical change in the property. So a wheelchair ramp, or a bar in the shower, or at the top of a stairwell to stop someone from falling. Those types of things are modifications versus accommodations, okay? So Ryan, want to go to the next slide? The distinction between the two happens in the analysis. First thing that a person has to show is that they have a disability. Now, as an HOA, if the disability is obvious, you can't ask about it. If it's clear and plain, for example, a person is blind and they want an accommodation related to their blindness, you can't ask about the disability. The more difficult part of the analysis is nowadays, what's become more prevalent, I should say, is when the disability is not obvious, like a mental health disability, or even a physical disability, but it's not an obvious one, like blindness or hearing impaired or mobility impaired, things like that. That makes the analysis a little more difficult. But the first step is, are they disabled? Second, is the request necessary to the equal use and enjoyment of the property? So if it has nothing to do with their ability to receive equal use and enjoyment of the property, then it can be denied. But if it has something to do with that, then yes, it's allowed. There must be a nexus or a relationship between the
Look
accommodation
at the minutes
request
question about
or the
executive session.
modification request and the handicap.
Minutes.
So-
only recorded action
If
taken.
you're getting into this,
Motion,
if there
second
is a
vote, not the
request,
discussion.
This is
Right.
one of those situations where I am going to encourage you to contact legal counsel, because you don't want to mess it up. The ramifications of messing it up are
But it should never show anyway,
very,
executive
very
session
bad.
or not.
and there
You
is
what?
a like
Discussion should never be shown
will not
anyway,
cover
executive
that
decision or
mess up.
not.
So once you get a request, talk to a lawyer. And one other key piece about the request is it doesn't have to be formal. They don't have to say, hey, I want a reasonable accommodation, or hey, I want a reasonable modification. What they can do is they may say, hey, my legs are causing me trouble and I can't mow my grass. And HUD or Foley in the state of Oregon will consider that a reasonable accommodation request. So be careful, and on these types of issues, consult legal
Dave tried
counsel
selling this
early.
Linda Brown is
Yeah, basically, if somebody invokes a protected status, right, Chris, and they're asking for some sort of exception to the rule and they invoke a protected status, you need to treat that like
That's
a
right.
request. Okay.
Yeah.
You ready for? I mean, one of the most common requests
Here we go.
that we get is a request for an exception to pet rules. Governing documents often prohibit certain types of pets, or limit the breeds, or limit the weight of the pets. You know, there's a misconception out there that that in order to have a quote service animal, that animal needs to be trained to provide some sort of
minutes
specialized
for the record of what
has some
happened
sort
at
of
the meeting.
specialized
There's
ability.
nothing else. What?
That may be true under the Americans with Disabilities Act. That has a very narrow definition of what counts as a service animal. But under the Fair Housing Act, you can get what are called companion animals as a reasonable accommodation. And those companion animals need no special training. They just need to be able to help the requesting person with their disability. So the most common request is for a companion animal to help with anxiety or depression. And so long as the person can establish that they're disabled and can establish that that pet helps them with their condition, they're going to be allowed to have that exception under the Fair Housing Act. Now, I personally find a lot of these very frustrating. Not because I doubt that there are legitimate requests out there. I'm sure there are. But what I see happen a lot is you tell someone their pet's not allowed. They make no mention of having a disability or anything like that. They say, well, we didn't know the rule. And then you go back and say, well, it doesn't really matter that you knew the rule or not. You need to follow it. And then they Google it, and then they figure out how to get around it and make the request. Having said all that, generally speaking, if you make them go through the steps and do the due diligence, you're usually going to allow them to have a companion pet. Chris, do you have any other thoughts to add to
Covered
that?
it all. Just remember, and I'm jumping to the next slide. Service animal is not a pet, so if you have pet restrictions, that they're not a pet. An assistance animal, a companion animal, they are not pets. In that capacity, they are a working animal, and you have to respect that. Now, that doesn't mean that you can't enforce other provisions related to noise or cleaning up poop or limiting urine where a dog or a cat or whatever the animal is can urinate or defecate. All of that is fair game. But a lot of you have provisions in your governing documents that limit the number of pets or limit the number of animals to 2 or 3 or the types or the size or the weight. None of that applies. That's where they're asking for the accommodation. I want to have a dog that's greater than the 40-pound weight limit, or I want to have this extra dog even though I have 2 other dogs and you have a cat. Well, this extra dog is not really a dog. It's not a pet under that restriction. It's a service animal or an assistance animal. I prefer the term assistance animal, but there are a lot of others that are used by HUD or DOJ. All right, let's move on, right? I think we've covered that.
Wow.
Look at all these fancy graphics that we put in
Incredible
there.
information.
I know.
You really went out of your way to make this one, Chris.
Yes, I did. All right, let's talk about administrative claims. Ryan, why don't you give the background
She
and then
needs a
I'll tell a story of one.
Who?
Oh
Linda
man, we could tell
Brown,
a
doesn't
story
she,
all
though?
day about this, couldn't we?
Yes, we could.
Too
I
bad
think
her
one of the
name is
things,
too
one of the
common.
reasons we wanted,
I'd Google her.
one of the reasons I wanted to talk about the Fair Housing Act is that the claims are made a lot, and the reason that they're made a lot is because it's actually pretty easy to make a claim. There are 2 agencies. There's a state agency, BOLI, which will accept Fair Housing Act claims, and there's the federal agency HUD, which has an office in Seattle that also will accept Fair Housing Act claims, and they will do most of the work for an owner making a claim or a resident making a claim. So all the owner has to really figure out is that they have to figure out the phone number to call. They can call up and make their complaint, and somebody on the other end is going to write it up for them. They're going to get the process going. They may even sort of ask them questions that direct them to, prompt them to say information that will bolster their claim. And then once that's done, they will write a letter to the association, and they'll say, all right, you've got 10 days to respond to this. Let us know what your response is. And the process appears informal, but the outcome of the process can be very serious. Because if HUD or there's reason to believe that discrimination has happened, they have the option of filing a lawsuit against the association. And they have their own resources and their own attorneys, and they will be prosecuting that claim, which they can do in their own name, and you will be defending it on your own dollar. So basically, if a complainant can convince the agency that there's something to it, then the consequences can be serious. So I've spent a lot of time in recent years responding to these claims, sometimes again by people that are not credible, to try and head them off before they get too far down the road. The general process is that they send you a letter. You have a certain number of days to file a response. They want you to provide a statement with your response that it's true and accurate. They want you to provide any records you have that are relevant. And it's assigned to an investigator. HUD has an investigator, and usually what they will do then is they will reach out to all of the named parties in the complaint. Another aspect of these complaints is that they usually don't just name the association. They often name individually the board members who the owner believes is acting in a discriminatory manner. So board members have some personal exposure on these, which can be scary for them. So then HUD will reach out. It'll interview all the people named personally and individually. And then at the end of that, they write a report, and that report says either they believe there is cause to believe that discrimination has occurred, or there is no cause. And if they believe there's cause, then they might pick it up and run with it. If there's no cause, then that's the end of the government's involvement in the case. Although, having said that, the owner can then go, if they want, they can still go and file a lawsuit. Now, usually they don't do that, but they have that option. So the other thing to be aware of is that you as the association, as board members, cannot retaliate against an owner who files a complaint, even if the complaint has no merit, even if BOLI finds that there is no cause. So you get to the end of the complaint, and my advice to my associations is, not to be too heavy-handed about it. A lot of the time, the board wants to go out and trumpet the fact that they won. I usually say, you can't. So it's probably an association record that needs to be shared, but I say don't rub it in. Don't take any adverse action against the owner afterwards based on the complaint. Don't disparage them. So otherwise, you can end up with round two, where you have a retaliation complaint. Chris, you had a story you wanted to tell.
I got a bunch of stories, so I'm going to tell a couple quick because we're about out of time. So, one, I recently had one that resolved. It was a complaint filed by a client of mine that I represent in the Boise, Idaho area. It went through Seattle. It was a homeowner who was behind in assessments. HOA moved to foreclose. They filed bankruptcy to stop the foreclosure. Bankruptcy didn't end up following through, so the HOA continued. So they filed a complaint against HUD, claiming that the HOA was discriminating against them. the intent behind it was to stop the HOA's collection efforts. The allegation was that all the members of the board were members of the Church of Jesus Christ of Latter-day Saints, and the owner was Catholic, and so they were being discriminated based on their religion. Went up to HUD,
What?
did the investigation. I worked with them. We had
How can
the
you justify
treasurer
that for
had to
why
give
we're trying to
testimony
get our
to the HUD
HOA money?
investigator. We tried to do the conciliation process to settle it. It didn't settle, so we went through the process. Ultimately, HUD said no, and of course, the best piece of evidence we had is that the treasurer, who was the longtime treasurer, said, "Well, I'm not a member of the Church of Jesus Christ of Latter-day Saints either, so no, they're wrong." And ultimately, HUD realized that the complaints that all the board members were Mormon or not Mormon was not true, and there was no discrimination. But that was one issue where the HUD case was used as a crutch to stop a collection action. Fortunately, the HOA won. Eventually, we got the homeowners out. In fact, it happened just earlier this year. It was probably a 3 or 4 year process where all this happened. But it is something that can be weaponized by owners if they don't like the action where it's taken. The other one I wanted to talk about was a
Okay, Bob.
disability case where we had
Why is your hand on the bottom instead of the
55
top?
and older community, which limits the age and the amount of
Because
time
when
that
my mom comes,
children under
she'll be able
the
to.
age of 8 or under the age of 19, 18 and under, sorry,
Nice.
can be
I saw
there.
the button. I couldn't figure out.
That's what
These
Yeah.
folks
Oh,
adopted
and then you can just pop it open and
granddaughter.
look at it.
Apparently, the mother
Nice.
had some issues, so they
Yeah,
officially adopted the
Yeah.
granddaughter. Grandmother was having health issues. They needed a care
Some comedian
provider.
brought a roll of
The
condoms
governing
to
documents
Herschel
allow care
Walker's
providers, but they wanted the granddaughter
event.
to come in before
Handed it
school
to
and
him.
after school and
Give it to
live
him.
with them to be the caregiver for grandma,
Okay.
which violated
And all people
the,
want is a
the
photo op with
housing
him
for
because
older
he's Herschel
person
Walker.
status
I
that
think
this
he gives a shit
community
about
had.
anything else.
Ultimately, we kept going
Oh
back
my
and forth
God.
saying, "Hey, why do you need your granddaughter? Why do we
Hey,
have
it's
to
Nick
give this
Cannon that needs the
accommodation?
roll of
What's the
condoms. No
relationship
shit.
here between the
God dang,
disability
he's got 9 kids from
accommodation
6 different
I do
women.
9 or 10. I think he might be up to 10.
Well, he's got 2 of them are pregnant or
Right, and I thought that
to
made
let
10.
her
I don't
in.
know.
And we never got a very good answer. So they filed a claim against HUD. We went the rounds with this one again, more testimony given.
Trevor North thinks we
HUD
should give Herschel
ultimately
Walker a
dismissed the case.
certificate
Ryan,
that
go
says
to
he's
the
an
next
honorary
slide
senator.
if you would. HUD ultimately found no
He
problem
needs a
with it.
badge to go with it.
Yeah.
And this is
No, he's
the
already got the
letter that
badge.
came
I
from
know,
that one.
but the different
A
one to that.
A Senate
Yeah.
badge.
September
Senator
of
Another
last
prop.
year.
Don't they have
And
something
ultimately
on
what
there
we
they wear on
won
the
Right,
lapels?
It was a difficult process. A couple of the directors were named personally, and the claim process is not fun. And so this association heeded my advice and got me involved early, which is a good thing. Again, I can't reiterate that enough. If there's something at all that comes up, get involved, get a lawyer involved early, get that advice so they can steer you through. We highlighted this language because this is the retaliation language. HUD put it out there. So
Wow.
even though HUD sided with my folks, HUD's saying, one,
that
they
is?
can still sue you, and two, don't go back and do a happy dance on them. You gotta, act like you've been there
Shirley?
before and let it go. Move on, don't retaliate.
Shelley Long.
So
Yeah.
that's a
Yeah.
key thing, and it's not always easy for boards to do,
Yeah.
but you got to do it.
We
Yep.
all age differently, don't
All right,
we?
Ryan, I think we're out of time. Anything you want to add on the process?
Oh, I was gonna say, I think it's good to do reconciliation. You mentioned that, and that was something I skipped over. But a lot of the time, the reconciliation offer you're making is to the same person who is investigating it, and so it makes you look good if you're trying to resolve it, and you have an opportunity to try and resolve it with the same person who's going to make a decision on whether or not the case continues. So that's kind of a nice little strategy there.
Yeah. And go to that last slide. I think the last slide had insurance.
Oh yeah, another very
Some insurance policies. I'm seeing better stuff lately where it's covering fair housing claims. But if you look here at the highlight, this is an exclusion. I think this was a State Farm policy, although don't quote me on that. But it says this is the exclusion section of the insurance policy. and it says that humiliation or discrimination when arising out of the willful violation of any civil rights law, whether federal, state, or local ordinance. Well, the Fair Housing Act, both in
Not
Oregon
covered.
and the federal act, would apply to this. And this includes, but is not limited to, discrimination based on account of race, religion, sex, age, familial status, or handicap. So, not covered, which means if you're not covered by
Right.
insurance, what are you, Ryan? You're self-insured.
Self-insured.
Yeah, you're self-insured, which means
Exposed.
you're paying the premiums by assessing your homeowners to provide that insurance, and nobody wants that.
They're
So,
paying they're paying the indemnity. This is something where there are a lot more policies. Like probably 10 years ago, almost all policies excluded this, maybe longer. But nowadays, there's a lot more coverage for these claims. That's something that, as a board member, when you're buying insurance, that's something I would definitely ask: is do we have coverage for Fair Housing Act claims, discrimination claims?
yep. That's absolutely right. All right, I'm gonna have Terry bring it up. Michael's already here, so Michael, you can turn on your camera, bring